So we've talked a bit about the UK, and now I think one of the key topics to talk about is EU legislation, the EU Whistleblowing Directive. And I think kind of before we get into it, I suppose I'm really interested in, why did it come about? What is the EU directive trying to achieve? And I suppose, how's that going?
How's it going?
How's it going, Sarah?
Well, I think the intention behind the EU directive was a really noble one. It wanted to harmonise and provide a consistent framework for reporting across all EU member states in the same way that the anti-money laundering directive tried to harmonise anti-money laundering controls across the EU. The issue was that within the EU, all of the countries almost were at different points and different maturities in their compliance in this area and place different value and were at different points culturally in their protection of whistleblowers. So it's had some real teething problems, not at the firm implementation stage actually, but before that, at the country implementation stage. So there's been real issues politically within a lot of countries in getting these things in force. I think it was last month Poland was fined, I think it's 7.1 million euros for still not having put in place appropriate legislation. And only 5 of the European countries managed to get their act together within the time that had been designated. So that has been the key problem. And now where we have come to, unfortunately, is that the countries have taken the EU directive and interpreted it in its application. So it's not quite as harmonised or consistent as one would hope.
So what are the kind of key things that it's trying to do?
Yeah, so the key things is similar to PEDA. It wanted to put in place the protections for whistleblowers, but it took the chicken of our chicken and egg situation, and it wanted to put in place appropriate reporting channels. Now, it was quite limited in its application. It's for breaches of EU law, which is wider than it sounds. It includes all of the EU financial crime legislation, financial services legislation, environmental legislation, data protection, public procurement. So it is wider than you would think. But it says if anybody's reporting a breach of one of these potential issues, there has to be a means for reporting. And it was initially said that it was all companies with more than 50 workers must establish those procedures. And when you receive a report, you have to acknowledge and respond to it within 7 days. You have to investigate that report and you have to provide feedback. So a fairly simple starting point, which was interpreted quite differently in different states.
So do you have any kind of examples of how different countries have interpreted that differently?
Yeah, so some have gone higher. So some have said, actually, this is going to apply to everybody. We're going to, all companies, all public companies and private companies should have these protections in place. So Latvia and Spain have gone high. Cyprus says all public entities, regardless of the number of workers. Private entities still have that 50 or more worker requirement. And Greece, all private organisations in certain sectors. So financial services, products and markets, transport and environment, no matter how big your company has to apply. Number of required channels can vary by country. Spain says you have to have a special channel for reporting harassment in the workplace. So that's an unusual one, an outlier. And some countries have stuck to just what the directive says in terms of the applicability. So it's Greece, Croatia and Romania have just stuck to the European directive in terms of its applicability. But in Germany, for example, we have breaches of criminal law are reportable through those reporting channels. Spain, any misconduct of public interest. France, serious and manifest violations of international commitment, which is a fairly broad topic. And then in terms of its anonymous reporting, that has been a big one, and I'm sure that's something that you've all had to contend with. And I don't know whether you want me to mention a couple of the oddities in that area, or whether you'd like to talk to it first.
No, I mean, it is definitely something that we speak to our customers about an awful lot, Sarah. It's certainly something that's perpetually on their mind in terms of something that they feel is a real crux of the issue when they think about whistleblowing, is where across my footprint do I need to be aware of where can someone report anonymously, where can someone not report anonymously, where might I be found by an enforcement agency to have strayed over the line. Examples where we've implemented very large international whistleblowing frameworks, and you might have the likes of Bulgaria, where we've got things where we're not allowed to report certain issues, we're not allowed to report in certain ways. Anonymity might be frowned upon. Even historically, when we think about Spain, so we've worked across multinational jurisdictions for quite some time, and Spain has some oddities in its very old legislation before the whistleblowing directives and things came in, where people weren't quite sure whether anonymous reporting was allowed, or that's what we hear from our customers. So it's always it's pulling all of these different crossed wires, for want of a better word, together, and understanding how we can start to separate them and understand what someone actually has to comply with, and where they want to set the bar. Do they set the bar at the highest level, or do they look to implement varying different systems across different jurisdictions?
The final question, I suppose, on the EU legislation sort of topic, before we move on, is what are the risks then of countries or companies falling short of the legislation requirements?
So that's a two-part question, I suppose. So each EU state will have its own consequences for failure to comply. But when you are thinking about as a UK firm, first of all, just because you're based in the UK, just because you have your head office in the UK and you're registered with Companies House, doesn't necessarily mean that the EU directive will not be applicable to you. So the EU directive is effective when you operate within one of those EU states. So it doesn't require you to be registered resident, have your head office in that state. So there's going to be a lot of UK companies with an EU presence that will be caught by that legislation. So lots of different types of penalties. We have most EU states will impose a fairly significant monetary financial penalty for non-compliance, which is obviously not great in and of itself. We also have Hungary, who doesn't appear to want to do anything, which is great for your Hungarian companies or your operating in Hungary companies. They will give a sort of public telling off to people that don't comply. But there's also a couple of states where they're introducing criminal offences for non-compliance, which is obviously something to be very mindful of in terms of your legal risk. And as I said, being resident in the UK is not going to be a defence to not complying if you are operating in those countries.
So I did say that was the last question, but you've made me think of another one, which is, it's interesting, like just listening, because I know that different states and different countries have done things differently, but it seems like there's such a range of different approaches, from nothing at all being the repercussion to a criminal offence. How do you, and this is a question for all of you really, but I'm looking at you, Sarah, because you're talking about it, but like, do you think then that the EU legislation is going to have to be looked at again? Because we're going right back to the beginning. It's kind of not necessarily achieved its original aim by all of these different interpretations.
Well, I suppose that's the point of EU law, right? States can decide how to adopt it. It wasn't a requirement to put in place criminal sanctions. So some countries can decide that that is proportionate to the ask, and that's how seriously they want to take it. Others decide that actually it's much more proportionate to give a public reprimand. So I don't think it will be revisited on that basis. And of course, because it's taken so long to get the legislation in place and for companies now to have to adhere to it, we've not had any prosecutions anywhere yet. So I think the answer is let's wait and see.